legal project. It is a political project. Now, before I even begin to, I will have to seek your pardon. I will not be addressing concrete provisions of this law. I would prefer to raise this discussion to the level of principles and then leave it to you to read these laws and check whether these principles have been satisfied. So let's begin with the very first principle that we have, and that is that we are a country governed by a constitution. No one can dispute that proposition. What does it mean when we say we are a country governed by a constitution? It means that we are governed by the rule of law. And what does the rule of law mean? The rule of law means that those who govern us are also governed by the same laws that apply to us. When you read these laws, look at it from that point of view. You will find that there are provisions in the law which are intended to protect public servants from being prosecuted. A liberalization of the regime, or rather a tightening of the regime, which enables us to bring complaints against public servants. And on the other hand, a liberalization of the regime which enables the state to prosecute its own citizens. So I would like to dwell a little bit on the concept of the rule of law before I move forward. As I said, the first and fundamental principle of rule of law is that we are a country governed by a constitution. We all know that the essence of the constitution is contained in its preamble: secular, democratic, republic. We know that sovereignty resides in the people. And we are mature enough to know what is the content of democracy. After all, we've had 75 years. It's a country which has been marked by periods when democracy was eclipsed. But it's also a country which knew how to come back to its own feet. And then it's a country which, in the last 10 years, has seen an attempt to move away from secularism to Hindutva rule. So when you read these laws, first and foremost, remember the context in which the country is situated. Of course, it is not my mandate over here to go over the several steps which have already been taken to move towards a Hindutva state. But after 4th of June 2024, I have been very closely observing newspaper headlines. And every day you open the newspaper and you will still continue to see an attack on minorities. You will still continue to see an attack on civil libertarians. You will still continue to see an attack on human rights defenders. One of the most recent examples has reached the doors of the Supreme Court of India, where the state of UP issued a notification in which it said that the names of vendors of food should be displayed. The agenda, not so hidden, was to cut out minority communities from the vending of food. I think it was Owaisi who correctly described it as a form of untouchability. Fortunately and mind you, this has happened after the 2024 elections. The point I'm making is that, sadly, when I observe what's going on in the country, I believe that the ruling powers have not understood that the mandate of the election was the rejection of the Hindutva agenda. It is a different matter that they formed the government with the help of allies. And it was rather sorry to see the President of India make a major legal error in her speech when she said that we are a majority government. It is not a majority government. It's a coalition government, which is very different from a majority government. But this seems to be the level of blindness that we see in our government. So if this is the context, and Comrade Vrinda recently reminded me never to forget what was attempted in the state of Maharashtra. tabling of a bill uh, which attempts to define who is an urban luxury and how to deal with that. Now, this is the second point that I want to make about dictators and the whole obfuscation of language, or I would say reinvention of terminology and concepts which we have never known to exist in Indian law or under this constitution. I remember the first time I heard the word urban nutshell, I was asked by some television anchors, ma'am, will you come and speak about it? I think it was in the context of the Bhima Koregaon case. And the first thing I said is, can somebody define for me who is an urban nutshell? There is no definition of urban nutshell in our laws. What did the state of Maharashtra try to do? They tried to fill in this gap. They're filling in the gaps with language which has never been part of legal language. And we'll come to it in a minute, all this in the name of decolonization. So we'll deal with that decolonization issue a little later. But for now, we need to understand the corruption of language that is taking place in this country. And why is it so important for us to understand that? It's important to understand it because law is about language. Can we ever forget that? Can we ever forget that law is the written word? And all of judicial process is a question of interpreting the written word. Interpretations can be several. So, it is for the first time, I have to say, in the history of this country that I have seen new words which are not legal words being invented in legislation. And urban luxury is one of them. Now, let's come back to fundamentals. Why is it so important that something like urban luxury be not defined? Why? Now there, I would like to take you back to the fundamentals of criminal law. What is criminal law? What are we discussing today about these three new laws? We are discussing crime and punishment. Crime and punishment. So let's discuss what's a crime. A crime is something that I do an act. It's called actus reus, the act of guilt. And when you call it an act, what you're saying is I have used my body to perform an act. If I stretch my hand out and pick up this glass of water, it's an act. If I pick up a gun and shoot somebody, it's an act which I have performed with my body. There is a guilt attached to that act, and that is the actus reus. That is what is punishable in law. So when you use an expression like urban luxury, what are you doing? You're criminalizing a thought. What we are seeing now is the criminalization of thought, which no country in the world accepts. There is not a single country in the world which accepts the criminalization of thought. Crime is an act which is performed with a guilty mind. So the very fundamentals of criminal law are being undermined by the trend in legislation that we see in this country today. This is something we have to reject outright. Cannot accept a criminal justice system. Why do we use the word criminal justice together? Why? Why don't we just call it a criminal system? There is a purpose behind it, because criminal law is actually supposed to serve the cause of justice. There are victims of crime who want justice, and that is why we call it a criminal justice system. There is a role for justice to play in a criminal justice system. So that is a point that we need to take note of. Criminal law also serves the cause of justice. And when we look at these laws, we need to check, do they serve the cause of justice or do they undermine the cause of justice? And this then brings me to the issue of the stated objective of these laws. Stated objective of these laws, there are two. One is decolonization. This is what has been spoken about in the public domain, and I take it that it finds its reflection in the titles to the Act. Inter alia, There are other things about it which we will come to in a minute. And the second is that they want to speed up trials. The third is that we have given rights to victims. The fourth is that we have made technology available to investigation of crime, and therefore we've made crime investigation more scientific. Now, if you look at each of these one by one, you will understand how hollow these claims are. I'll not go into the question of name because many people have already spoken about it, written about it, and it's rather obvious when you see that even judges can't remember the names of these laws, you understand how meaningless it is. And others have pointed out that it violates the provisions of the Constitution of India. But certainly, it introduces on the table the whole issue of federalism, about we will speak a little bit later. Let's focus on the decolonization issue, because after all, decolonization is something a little deeper than just changing the name. Now, this is not an easy, I will admit that this is not a very easy issue for me to address, and I think scholars worldwide are still trying to understand what decolonization means. I'm not talking about these laws, but generally the decolonization that we saw after 1947 in country after country, after the Second World War, after the United Nations introduced the Charter on Human Rights. The world saw a turning point in world history when the United Nations was founded with the Universal Declaration of Human Rights. And it is those human rights, civil and political rights, which ultimately found a place in our Constitution. So, to me, it seems obvious that the process of decolonization was the process of conferring rights on citizens, which is found in Part 3 of the Constitution of India. Again and again, we go round and round and come back to the Constitution of India. There is no escape from it, as the anchor on which all our arguments revolve. So, to me, as a lawyer, as an individual, as a practitioner of the law, the process of decolonization took place from 1947 onwards, and it reached its culmination almost in the Constitution of India with the enactment of the preamble to the Constitution, as also the conferment of fundamental rights of individuals. This was a turning point, as I said, in world history. Not the history of India, not the history of Africa, not the history of the United States of America, but the history of the world. It was a major change. So, today, if somebody turns around and tells me after 75 years of independence that we are decolonizing our laws, my only question will be, did we not do it in 1947 when we conferred fundamental rights on citizens of the country, yes or no? First, let's have an answer to this question, and the answer for me is yes. So what is it that we're trying to do? In my opinion, it appears to me that we're trying to go behind the Constitution of India, to an era before the Constitution of India was enacted, to an era before the United Nations declared the Universal Charter of Human Rights. That is the process, and that is what links up with the Hindutva project. The Hindutva project is an effort to return to an era before colonization, and that can only be described as Brahmanism. There is, in my mind, no other name for it. So, if Brahmanism is a system of hierarchy, if hierarchies need discipline, hierarchies need to be put in place by punishments, this is the function that this particular criminal law which has been introduced will be performing. If it was a genuine decolonizing effort, there would be 2 or 3 things we would see in these new laws. Number 1, police reforms, a system of making the police accountable, reforms of prosecution. We do not have a system of independent prosecution in this country at all. Some states do have a directorate of prosecution, but they are reporting directly to the Ministry of Home Affairs in their respective states and in the center. How can you call it an independent directorate of prosecution? These would have been the kind of reforms that you would like to see if you were talking about an effort at decolonizing your laws. That has certainly not happened in these laws. Even the Supreme Court has repeatedly called for police reforms. Issues stuck. The states are saying, we are not going to do it because this is a subject which is within the domain of the stateless. Now that brings me to the whole issue of federalism. But before coming to the issue of federalism, I would like to say a few words again, as I said, the Constitution of India. So what is it that we are talking about when we talk about the law of procedure? We are squarely talking about Article 21 of the Constitution of India. No person shall be deprived of life and liberty except by procedure established by law. What is this procedure established by law? It's the Criminal Procedure Code, which is now replaced by the BNS. So there is a direct link between procedural law and the Constitution of India. We cannot discuss one without discussing the other. And the only question that we should be discussing in forums like this is, does this law conform to Article 21 of the Constitution of India and Article 20, Article 22, etc., the whole set of rights, Article 19, 1A, Article 19, 1B, Article 19, 1C, the right to free speech, the right to associate, the right to form unions, the right to form associations. Are those rights impacted by these laws? That is our way, that ought to be our way of looking at these laws. And I'm sure that the speakers who come after me will be addressing some of these issues. My task here as an inaugural speaker is to put on the record the basic principles on the basis of which these laws are to be evaluated. So, 3 of the basic principles I have pointed to: the Constitution of India, Article 21, the principle of federalism. We'll move on to that. Now, why do we raise the question of federalism? We raise the question of federalism because policing, and law and order are state subjects. They are not subjects in the union list. However, the concurrent list does contain a provision which enables the central government to enact laws relating to criminal procedure. And that is a constitutional power that they have used to enact these laws. Let us say Indian Penal Code was a pre-constitutional law. It existed when there was no constitution. Criminal Procedure Code, of course, in 73 was reenacted in a central law, but we learned how to live with it. Indian Evidence Act was also a central law. But today we have the center enacting these 3 laws, which are enacted in perpetual exercise of powers under the concurrent list. And this is the reason why I say it brings up issues of federalism. Were the states consulted? The answer is no. Many states have gone on record to say that we were not consulted when these laws were passed. We know that MPs were suspended in Parliament when the law was given its the assent. We also know that requests to invite former judges have gone on record, and MPs have gone on record to say we gave long lists of witnesses who we wanted them to call you. We wanted you to call them before the select committee. They were not called. So leave aside consultation with the states. Even Parliament's own procedures were not complied with in the enactment of these laws. And this is the reason why I had addressed a letter to the Law Minister, making a simple request just to defer the implementation of these laws till the new Parliament had time to look at them. That's all. Nothing more, nothing less. It's a very, very simple device. governments have the power to decide when to bring laws into force. And I was hopeful when I wrote that letter that at least one of the allies would pick up on this and request the centre that you just defer the implementation of these laws until we have had an opportunity to re-look at the content of these laws. And sad to say that the allies did not pick up on it, did not, at least not to my knowledge, make this request. And the second reason why I wrote the letter was the extraordinary burden that would be imposed on the courts in the implementation of these laws. And why do we say that? We say that because, as I have said before, and I will say it again, we have two parallel criminal systems in this country. One, which is the pre-1st July 2024 system, one, which is the post-1st July 2024 system. And why is that? Again, because of the Constitution. Article 20, which says no person can be punished of a crime which was not a crime on the date when it was committed. Therefore, we are protected as far as substantive laws are concerned, the Bharatiya Nyaya Sanhita. We cannot be convicted under the new law for something we did before it came into force. But the same is not true of procedural laws. Procedural laws can, litigation in this country can go on for 10, 15, 20 years. Only this morning, I think I was reading an article about a person who had been declared a citizen 2 years after he died. It's very, very common in this country for litigation to be without end. You can say that, without end. In my own case, I know I have an FIR which has been pending for 5 years at the stage of investigation. So, all those cases will be governed by the law which existed before these three laws came into force, and you can anticipate. I heard a story which was very, very strange. I heard that the union government is planning to issue some notification repealing the three laws. Now, whether this is true or not, we have to detail. In that case, the major question will be, how are we going to deal with Article 20 if the laws are repealed? They are going to issue SOPs, they are going to issue guidelines, they are going to issue practice directions, I don't know what else they are going to issue. But if the law which was governing me when I committed a crime is going to be repealed, then how will Article 20 of the Constitution of India be satisfied? There's no way that I can be governed by the new laws which came into force for a crime which I committed before the laws came into force. It's gross. So, of course, we know that states have have formulated committees which are looking at the kind of amendments that can be made at the state level. Now, this is a very, very healthy development. And the more states that come forward and say we are making our own laws to replace the existing laws, the better for the citizens of this country. But the big question is, under the Constitution, all laws which are made by the state, covered by the concurrent list, have to await the concurrence of the President of India. And the big question is, given the kind of political commitment that this government has shown to these three laws, will they give concurrence to the states when they choose to amend these laws? Amendment of criminal law is not unknown. Because the Indian Penal Code has been amended by states, the Criminal Procedure Code has been amended by states, and all these amendments have received the concurrence of the President. But will they? Now is a big question which I think the MPs in this meeting will be better placed to answer than me. And certainly I would be very much interested to see the SOPs that are being issued under this law as to whether these SOPs will provide guidance to the courts. Of course, it's entirely a different matter that some of our judges jumped to welcoming these laws even before the full impact of them could have been understood by people like us. I will now move directly, since we have other speakers over here, they will be addressing some of the issues. The two of by far the most deadly provisions of these new laws. One is the reenactment of sedition in a new avatar, and the other is the introduction of a terrorist act into the new criminal law. Two of them. Let me first begin with sedition. Of course, we all know that commitments were made by this government to the Supreme Court of India that the law related to sedition will not be implemented. In other words, there was a stay of the implementation of the law of sedition in pending proceedings in the Supreme Court. More than 20 petitions are pending. What do we see today? What happened to that stay? It's gone. Because the stay was in relation to the old law. We now have a new law. And there's nothing to stop the union or any state to lodge FIRs under the newly enacted 152 of the Advocate Indira Jai Singh. Now that's not all. And here is something that I would certainly like some of the MPs to throw some light on. It has been referred to as sedition plus, and rightly so. Why is it referred to as sedition plus? Because some expressions from section 13 of the UFPA have been picked up and added to the definition of sedition. And what are those expressions? Three new expressions. Endangers the sovereignty and unity and integrity of India, or indulges in or commits any such act shall be punished with imprisonment, and it includes by any means whatsoever, including financial means. That was, economic security was in section 13 of UFPA. Now they've used the word financial means. Now what does financial means mean? Is it the equivalent of economic security? So I can only give you the commonest example that I am familiar with, and that is, let's say that we are opposing a mining lease. Let's say we are opposing a coal license to, say, Adani, Ambani, or just anybody at all. Are we thereby endangering the economic security of India? Because that metal, by the way, this has been argued in courts of law very seriously by prosecutors. My lord, it is endangering the economic security of India because this metal is required to produce defense equipment. Therefore, these protesters are jeopardizing the economic security of India. Now they go one step further and say financial means. So let's say if I'm participating in a demonstration, I contribute like 10 rupees, 100 rupees towards the cost of the demonstration, then I am by financial means attempting to excite or endangering sovereignty and unity and integrity of India. Now here is one thing that I would like some of the MPs here to address. The Home Minister claims that the definition of sedition has been narrowed down because instead of saying you have disaffection towards the government by law established, we now say endangers the integrity and security of India. So the difference is between government and India. And he claims that this law actually reduces the number of situations in which a FIR can be lodged under 152 as compared to the earlier. You're all familiar with the kind of FIRs for sedition that were filed under the old 124A. If you are not familiar, let me remind you that in the Delhi riots case it was used, in the Bhima Koregaon case it was used. Any kind of protest that was taking place in the last 10 years was inviting inter alia the crime of sedition, along with section 13 and 15 of the UAPA, the terrorism law. So it's very important and significant for us to understand the meaning of sovereignty and unity and integrity of India. One argument can be that it is preceded by expressions like armed rebellion, subversive activities is really, really beautiful. I won't be surprised if a meeting like ours is considered a subversive activity. Vague as ever, left to the imagination of anybody to decide what is subversive and what is not. Encourages feelings of separatism. Now, it's possible to argue that sovereignty and integrity of India must go with these laws, with these expressions. In other words, it must either be in the nature of encouraging secession, or it must be in the nature of armed rebellion. Only then can it be said that sovereignty and integrity of India is under attack. But there is no clarity on this subject at all. Search as you may judgments of the Supreme Court of India, I am unable to find a definition of what is meant by the sovereignty and integrity of India. So let me give you my understanding of what it is. In my understanding, India over here refers only to a territorial unit. Nothing more, nothing less. But we have heard arguments in the public domain that, oh, this state, when we go to international forums and we talk about inequality in India being by far the greatest in the world, the gap between the rich and the poor is the most in India compared to any other country. We are told that we are damaging, quote unquote, the reputation of India. Now, is that what is meant by endangering the sovereignty and unity and integrity of India? The answer could be a yes. So long as we live in this kind of draconian regime, the answer could very well be yes. So the only other way that has been found in judgments of the Supreme Court, one is the Ram Manohar Lohia case, where the court said public order, law and order, and security of state are three different concepts. Agreed, they are three different concepts, but do we know what is the exact difference between them? We don't. Ultimately, it comes down to a question of, please tell me when I have to stop now, almost finished. It's getting late, please let me know. Ultimately, it comes down to the severity of the so-called disturbance, the degree of severity. And who will make that decision? It will be the police officer who is lodging the FIR. So much for sedition. Last but not the least, they have introduced verbatim the provisions of Section 15 of the UAPA into the new law. Now the question here will be, what exactly is the law that will be used in the event there's an allegation of terrorism? Let me tell you, I'm going to just mention a couple of things and stop. Firstly, there are cases without number where the UAPA has been invoked where there is no terrorist act even alleged. That is what happened in the Bhima Koregaon case. Section 15 says whoever by means of bombs, etc., causes death. In the Bhima Koregaon case, not a single death occurred. No allegation that a bomb was used. The only allegation was that somewhere we found on somebody's computer a conspiracy to kill the Prime Minister of India. That's all. And for that reason, people have been in prison for more than 5 years. So we don't know now whether a police officer is going to use the UAPA or whether it's going to use this law, because the investigating agencies are different under the two laws. So it will be left up to the discretion. But apart from all that, it defies imagination why provisions of special laws have been put into a general law, and why there is a duplication and overlap of offences. I think not even the Home Minister has been able to give an explanation to this. I come to the last point, which is of some importance, and again I hope that some of the lawyers on this panel would press it, and that is the whole use of electronic evidence within the meaning of a document in the Indian Evidence Act. It's one of the most problematic provisions in the law, because no provision has been made for ensuring that the chain of custody is maintained and proved beyond reasonable doubt by the prosecution once the device has been confiscated. You all know what happened in the newsprint case. 200 devices have been confiscated of 200 journalists. At the time of confiscation, not a single one had a hash value taken. And some of you must know that the hash value actually shows you what was on the computer on the date that the computer was taken away from you. Those devices have not yet been returned. Biometrics have been introduced where in the name of forensic evidence, the constitutional validity of each of these provisions is, I'm sure, going to be tested. So where are we? We are with the law in our hands, which in my opinion, at various intersections, is clearly, to my mind, unconstitutional, clearly violative of Article 21, clearly violative of the rights of the accused. And it's not good enough to say that we've done this in the light of giving you timelines, because those timelines are never going to be adhered to. Finally, we are told that there are some rights of victims in these laws. Many others have pointed out that there is no victim protection program at all. I can point to you cases without number where victims of rape, from Hardress to now, where the victim has died before the case can even reach its own conclusion for want of a victim protection program. Accidents take place and the witnesses die on the street without any investigation as to how this person died. So it's hazardous in this country. If you are a victim and you lodge an FIR, you should be really prepared to be in a state where you almost face death. And remember, the Whistleblower Act has not yet been brought into force in this country. So I'll stop here, but I would urge you in your respective associations and organizations to think of this debate not about the nuts and bolts of this law, but about the manner in which it erodes the rule of law. And the rule of law is not something that we arrived at in one day. 4,000 years of human history stand testimony to the fact that we are today governed, nations governed by law, which is applicable equally to those who are in power. It is that rule of law which is endangered, and I'm happy that we are meeting here today to discuss how we can prevent the erosion of that rule of law. Thank you.